Civil and criminal jurisprudence will come to order. Since we're waiting on a quorum still, we're going to go ahead and operate as a subcommittee. First up, Senator Eslinger on Senate Joint Resolution 64.
Okay, well, good morning, Mr. Chairman. For the record, Senator Carla Eslinger, representing the 33rd Senatorial District. Senate Joint Resolution 64 would put to the people of Missouri a constitutional amendment to Section 32 of Article 1 of the Missouri Constitution. This would extend the statute of limitations to match the penal laws for all victims for all crimes. It is essentially a crime victims' rights bill with an extension of civil rights statute of limitations to match the criminal statute of limitations. SJR64 is a vital piece to ensure that our judicial system is able to uphold justice and protect victims from further harm, especially victims who are children. Victims of crimes should have the right to bring civil claims against the defendant within the same time frame as the criminal statute of limitations. This SJR, if passed by the legislature and then approved by the citizens of Missouri, would allow citizens the opportunity to heal from the crimes that were committed against them. I want to thank the Chairman Luetkemeyer for giving SJR 64 a hearing, and I know that we have people here in support and in opposition who are passionate about this legislation. And so I will close with that and give them plenty of opportunity to testify.
Any questions for the witness or for the senator?
All right, thank you. And may I ask to be excused right after this because I have another committee to go to?
Absolutely.
All right. Well, thank you, sir.
Could we get a show of hands, just how many witnesses in support we have? Okay, and then how many witnesses in opposition? Okay. We'll start with witnesses in support. Go ahead.
There we go. There we go. First of all, Chairman, thank you for allowing me to testify here today. My name is Catherine Robb. I'm the Executive Director of Child U.S. Advocacy, and we work on child protection bills all over the country, including statute of limitations reform. Presently, the data indicates that 1 in 5 girls and 1 in 13 boys will be sexually assaulted before their 18th birthday. And it also tells us that predators typically have hundreds of victims. In many states, we see over 200, sometimes 500 victims. The evidence also tells us that that victims suffer in silence because the predator silences them, and it takes years to come forward. In fact, the average age that a victim comes forward is somewhere between age 50 and 70, with the middle ground being around 52, 53, so well past the statute of limitations period. Sadly, some never, ever come forward. The cost to society is staggering. We have a lot of data on this. I did submit written testimony as well. Presently, the effects of child sexual abuse don't just affect the victim and the victim's family, but it also significantly affects Missouri taxpayers. The trauma just reaches so far and wide, and it burdens the educational system, the medical system, mental health services, social services, the work sector, law enforcement, and penal systems. Because of the nature of trauma, it creates a lot of issues in children when they're younger and as they get older as well. Issues of depression, attention deficit disorder, anxiety, suicidal ideations can really cripple victims, and this, of course, has a burden on society. This bill is part of a national movement I do think there's improvement for this bill, and I will save that for another bill that I will testify on if you don't mind. Presently, we have 30 jurisdictions that have passed revival legislation, 27 states, 3 U.S. territories. 21 jurisdictions have, and the federal government, have completely eliminated the statute of limitation for child sexual abuse. And why? Because lawmakers are responding to this epidemic where we have close to 12% of all children will be sexually assaulted before their 18th birthday. So they're responding to this. They're also responding to the nature of trauma and where these victims remain silent for years. You may hear from opponents that the courts will be flooded. We have data on 14 states where the courts have not been flooded. They function quite well. I am happy to share that data as well in greater detail if you need. But we looked at states like New York, California, Minnesota, Georgia, and others, where the average percentage was 0.002% of the population filed a claim. So we just don't see this flooding of claims. You may also hear that tort claims by their nature deal with terrible accidents, and some are catastrophic. I just want to say to this committee, these claims are not your typical tort claims. This is certainly not what I learned in law school in my first year tort class, right? We are talking about the rape, sodomy, and sexual assault of innocent young children. So they are very, very different. You may also hear that statute of limitations have a purpose, encouraging prompt filings, and allowing the best evidence. I want to tell this committee that as a U.S. citizen who believes in the Constitution and as an attorney, I believe in due process. I think it's important. However, due process is not absolute. It just isn't. We see it even for basic fundamental rights, right? There are exceptions to First Amendment, freedom of religion, and freedom of speech. Statute of limitations are, in fact, arbitrary time limits that are set by bodies as is here and in both chambers. We also have safeguards in place. We have the rules of evidence. We also have the rules of civil procedure that help filter out any potential false claim, which, by the way, the data presently holds that less than 4% of all claims are fraudulent or false claims. Plaintiffs still must prove their cases. False claims are exceedingly rare. I also hear that we have our criminal statute, right? Let the criminal statute work. And certainly, I believe that Missouri has done a great job in reforming the statute of limitations for the criminal statutes here. Bravo to all of you. However, what I must say is we cannot, one, revive statute of limitations, and two, we cannot, the criminal statutes are very, very limited. We have some interesting data about the percentage of claims that go forward, and it's less than 10% ever move forward to conviction. So the criminal statutes just aren't enough. Institutions do not change their ways until they may be held accountable. So you may hear some of this fear-mongering from deep pockets, and that's what they protect, deep pockets, not children. So I hope that you will consider moving this bill out of your committee. And I thank you, and I'm happy to take any questions as well.
Any questions for the witness? Seeing none, thank you for your testimony. We're going to do, it looks like there was only one witness in opposition, so we'll do witnesses in opposition, then we'll go back to witnesses in support.
It's a big number, though. At least it's a whole number. Hi, Rich Abishan on behalf of the Missouri Civil Justice Reform Coalition. Not here to fearmonger, but also to say she did a great job for testifying in my position. She's obviously done this elsewhere, and believe that all of her points are very valid for that. This is a very serious matter. Don't mean to fearmonger in that respect, but here's the thing. Obviously, we are involved in due process, whether it be for the defendant or for the plaintiff. And you can't believe in due process, but. And here's the thing for us, we believe in due process for all parties. Court should be fair. When we have due process set up, like we do in Missouri, where a statute of limitations that runs creates a constitutional right, which has already been established here in Missouri, that the case is final. We believe that should be the matter. There have been a number of states that have taken this approach. Missouri is somewhat unique in the regard that we have a constitutional provision that doesn't allow for retroactivity like this. I believe that's important for all parties. There should be some finality. I believe this is an important issue for the state of Missouri. I was helped part of the discussion in resolving the matter on the criminal sanctions for an individual who committed these heinous crimes. In taking that statute of limitations away from criminal sanctions, I believe that was also a great remedy. Not to be taken away from what we see here today, but the fact is that if you want to punish someone, you put them in jail. A lot of the criminal masterminds who've done these terrible things have gone to jail, and they should. We believe that's the case as well. We don't believe that we see the need to change our Constitution to allow for the convenience of filing suits just against what we've seen in other states, and we believe that the current law is correct. Happy to take any questions.
Any questions for Rich? Seeing none, thank you for your testimony. Since we do have a quorum present, I'm going to ask Madam Secretary, please call the roll.
Senator Luetkemeyer.
Here.
Schroer.
Here.
Coleman. May. Roberts.
Here.
Thompson Rader. Trent.
Great. We do have a quorum, so I'm going to make a motion that we go into executive session. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. We are in executive session. Now make a motion that we bring before the committee for consideration House Committee Substitute for House Bill 1659. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. Bill's before the committee. Just for the benefit of the committee, this is Representative Roberts' public safety bill that he presented on last time. Has a lot of provisions that are substantially similar to what we've already third read through the Senate in Senate Bill 754. I have a Senate committee substitute. We distributed a chart that goes through all the different provisions that are in here. Most everything that the Senate has already third read from everything that Senate third read from 754 is in here. Most of the remaining provisions are provisions that have come through this committee. They were identified because they were seen as mostly non-controversial. So everything in here should look pretty familiar. The two exceptions where something did not come through the committee. We have at the very bottom of the chart the update to the police chief training bill from a year ago. That was Senator Williams' bill. Passed as part of Senate Bill 186. There was a change that was made in the House that shortened the time frame for police chiefs to go through this mandatory training from a year, which is where the Senate set it to 6 months. That's proved difficult to comply with, and so we're simply extending the deadline back to a year, which is where the Senate had it. There has not been a bill filed this year. Again, I see this as a technical cleanup fix and consistent with the Senate position from last year. The only other thing that is in here that we have not had come through this committee are some updates to the criminal background check process that the Highway Patrol uses in Missouri in order to run federal fingerprint background checks. The feds are mandating that we make some changes and update to our statute. If we fail to do that this year, we will lose the ability to send fingerprints off to the FBI, which would be a pretty big deal. I think we have representatives from the Highway Patrol and DPS who are here. Again, this bill has been through a separate committee. Senator Bean sponsored it. It got voted through public safety, but because of the critical importance and the timing of needing to get this done, we felt that it would be a good idea to make an exception and put it in this bill, even though it hasn't come through this committee. So with that, I'd be happy to entertain any discussion. Otherwise, I'm going to make a motion to adopt the Senate committee substitute. Seeing no discussion, I would now make a motion that we adopt Senate committee substitute for House Committee substitute for House Bill 1659. It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes appear to have it. The ayes do have it. You have adopted Senate committee substitute for House Committee substitute for House Bill 1659. I would now make a motion that we do pass Senate committee substitute for House Committee substitute for House Bill 1659. It's been moved and seconded. Madam Secretary, please call the roll.
Senator Luetkemeyer.
Aye.
Schroer. Coleman. May. Roberts. Thompson Rader. Trent.
By By your vote of 5-0, you voted do pass Senate Committee Substitute for House Committee Substitute for House Bill 1659. I would now make a motion that we bring before the committee Senate Bill 1338. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. You guys have it. Bills before the committee. We do not have a committee sub on this. This is Senator Fitzwater's bill from a couple of weeks ago. This modifies provisions relating to the sex offender registry, adds that any person who committed a sexual offense against a minor is not eligible to file a petition for removal from the sex offender registry. Is there any discussion on the bill? Seeing none, I would now make a motion that we do pass Senate Bill 1338. Do I have a second? It's been moved and seconded. Madam Secretary, please call the roll.
Senator Luetkemeyer.
Aye.
Schroer. Coleman. May. Roberts. Thompson Rader. Trent.
By your vote of 5-0, you voted do pass Senate Bill 1338. I would now make a motion to bring before the committee Senate Bill 1390. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Those contrary, no. The ayes have it. Bills before the committee. I'm going to kick it over to Senator Schroer as this is his bill to explain it.
Thank you, Mr. Chair. This is the identical bill that we've had year after year. Finally reached an agreement with all parties. When you look at the substitute that sits before you, which I believe ends in O2C, we repealed a provision that barred retirement benefits for administrative law judges under certain circumstances. We modified several of the other prongs, included a provision herein which says, somebody receives an award for permanent total disability, but then is restored of their eyesight, or the injury starts depleting or going away, and they're restored back to normal, then the award can be suspended. And we tightened up a lot of the provisions on when these ALJs can be disciplined and how the hearing shall go. So with that, I'll answer any questions.
Any questions for the bill sponsor? Senator Roberts.
Thank you. And I think I remember from the hearing there was no opposition testimony to this, correct?
Yeah, I don't think on this version, because ultimately we were going to try to work out a deal. We've got that compromise, and that's what we're going to do to move forward, and hopefully everyone stays in the positions that there are right now.
Good deal. Thank you.
Thank you.
Any further discussion before we make the motion to adopt the Senate Committee Substitute? Seeing none, I make a motion to adopt the Senate Committee Substitute. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. You guys have it. You adopt the Senate Committee Substitute. Now make a motion that we do pass Senate Committee Substitute for Senate Bill 1390. Do I have a second? It's been moved and seconded. Any further discussion? Seeing none, Madam Secretary, please call the roll.
Senator Luetkemeyer.
Aye.
Schroer. Coleman. May. Roberts. Thompson Rader. Trent.
Your vote of 5-0, you have voted do pass Senate Committee Substitute for Senate Bill 1390. We are going to leave the board open for the benefit of Senators May and Coleman so that they can vote whenever they arrive, if they do arrive. And with that, I would now make a motion that we exit executive session. It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. We are out of executive session. We are back on Senate Joint Resolution 64. I believe next up is witnesses in opposition. Sorry, next witness in support.
Thank you, Chair. Elizabeth Phillips, Dallas, Texas. Thank you, Chair Luetkemeyer, for inviting this hearing on Senate Joint Resolution 64, which proposes an amendment to serve child sexual abuse victims in their pursuit of healing and justice. Thank you to Senator Eslinger, who represents the area where Kanakuk Camps operates in Southwest Missouri. This is a very hard but important topic when you think about it from the angle of child predators. To the committee, I'm here to speak on behalf of my late brother, Trey Carlock. Trey was silenced to his grave by Kanakuk Ministries based in Taney County, Missouri, the greater Branson area. Kanakuk claims to have hosted 500,000 children at their multiple camps in the Ozarks, yet their decades-long history of child sexual abuse was only recently exposed to the public. Since Missouri's current civil statute of limitations requires victims of child sexual abuse and trafficking to file civil action against a perpetrator by 31 and a liable institution by the age of 26, victims like my brother are forced to relive their nightmares when they're just trying to survive and heal. The male brain isn't even fully formed until the age of 25. So in Trey's case, he was prematurely forced to file, but he sued Newman, Kanakuk, and other third-party defendants to afford lifelong treatment, which is what many child sexual abuse survivors require. Just putting a bad guy away doesn't cover those lifelong costs. So the cost to society on this devastating ill can land on culpable institutions through civil remedies or on taxpayers. That's the choice. There should be no place for a civil statute on child sexual abuse or trafficking, past, present, or future. Please don't group this with things like slip and fall accidents. We're talking about child rape. Please don't group this with other tort reform bills. This is a critical step for child protection, an issue I know you all care deeply about, and it deserves unique attention. I'll reserve the rest of my testimony for Senate Joint Resolution 88 later in this hearing. Thank you.
Thank you for your testimony. Any questions for the witness? Seeing none. Thank you. Further witnesses in opposition?
Mr. Chair, members of the committee, Michael Henderson for the Missouri Insurance Coalition, opposed to this joint resolution for reasons stated by Mr. Abishan, especially as it relates to non-perpetrator defendants. Happy to answer any questions.
The question I have is there anything that the opposition side, and you may not know the answer to this offhand, but is there any compromise that the opposition side is willing to look at?
You know, I think we've been on record as saying, you know, when it comes to perpetrators, you know, expand the statute of limitations as much as you want. Certainly, when it comes to retroactivity on laws, I think that's problematic for the reasons already set forth in our Constitution and by the Supreme Court. I think when you talk about expanding prospectively statute of limitations on non-perpetrators, Senator, you know, it was brought up in the House. It's just the fact that this will certainly, especially from an insurance standpoint, have a negative impact on the ability of institutions like a small mom and pop daycare to even afford these products. If you expand statute of limitations prospectively from currently at 5 years to say 20 years, as has been proposed. So I think you know, we're certainly always willing to look at language and come to some sort of agreement on the issues. But as presently constituted, we have to be opposed.
Any further questions for the witness? Seeing none,
Thank you.
Further witnesses in support?
Chris O'Leary, I'm registered under 88, but I'm going to speak in support of 64 in part so I can get my mom home. And I've got hard copies if you want them. Statutes of limitation become an issue for survivors for many reasons. I'd be glad to touch on the story in a painting I have. But one thing I haven't heard discussed is the tactics, the dirty tricks, which make terms like due process. It just makes me laugh. The Catholic Church and its enablers use to keep survivors from coming forward on a timely basis. Dirty tricks to the point of today's hearing designed to confuse and sow doubt in the minds of survivors and create problems with the statute of limitations, as they did in the case of my October 2015 lawsuit against the Archdiocese of St. Louis. My name is Chris O'Leary, and I'm a survivor of the Catholic sex abuse crisis. In the late 1970s and early 1980s at the Church of the Immaculata in St. Louis, I was sexually exploited, abused, and assaulted, ultimately raped by a priest named Father Leroy Valentine. And then things got really bad. My abuse was witnessed, at least in part, by then Father and now Cardinal Timothy Dolan, who overlapped with my abuser, Father Valentine, in Immaculata for 2 years, from 1977 to 1979. I and others were sexually abused in front of Dolan, upstairs in the Immaculata Rectory at least. Coincidentally or not, in early March of 2002, in the aftermath of Spotlight and prompted by an article in the New York Times that named Father Valentine as an abuser, when I went to the Archdiocese of St. Louis for help understanding what my memories of Father Valentine might mean and what, if anything, had happened to me, by then Bishop Dolan called me back. Dolan lied to, manipulated, and gaslighted me, telling me my memories didn't mean anything, that it was impossible that anything had happened to me, sending me on a 10-year wild goose chase. But my friend Bishop Dolan said nothing happened, is a thought that occurred to me countless times over the next 10 and eventually 13 and more years. A thought I have to believe by design robbed me of the confidence I needed to talk to a lawyer who happens to be here, file a lawsuit in a timely manner, and force the Archdiocese of St. Louis to help me, because they refused to help me voluntarily. That's what I mean by dirty tricks. developed and coached by the Archdiocese of St. Louis's lawyers, to the point of suicide and why survivors kill themselves, it gets worse. Though it happened after my lawsuit and its disposition, I need to mention, because I know it's relevant to other survivors' stories and their willingness to come forward or not, my treatment by former Missouri Attorneys General and now United States Senators Josh Hawley and Eric Schmidt in August 2018, in the aftermath of the Pennsylvania grand jury report, then Missouri Attorney General and now United States Senator Josh Hawley opened an investigation of the Archdiocese of St. Louis, an investigation that was a complete and utter sham. I know that because out of a naive hope, I tried to assist in that investigation, submitting information to the Missouri Attorney General's office 3 times through the website, and also speaking to the woman who was heading up the team, Christine, whose name I got from John Hancock, who attended my mom's church. Senator Hawley and his team were utterly uninterested in what I had to say, so much so that I have to wonder if the Missouri Attorney General's office was running a catch-and-kill scam for the Archdiocese of St. Louis and the Catholic Church. After being harassed by a family member of First Assistant Attorney General of Missouri, Tom Albus, Albus's family member publicly accused me of lying about my abuse, I did manage to get an interview with the new Missouri Attorney General, Eric Schmidt's team, in February 2019. That interview led to nothing. I then went back to Missouri Attorney General Schmidt's team in late July 2019, forcing them to interview me again by pointing out the existence of potential criminal activity by then Father, then Bishop, and now Cardinal Timothy Dolan, covering up abuse in the 1970s, obstructing justice in 2002, and so on. Within days of that second meeting, then Missouri Attorney General and now United States Senator Eric Schmidt, a Catholic, killed the investigation of the Archdiocese of St. Louis, I have to suspect, in order to protect his archdiocese and church, and as a result of my naming and implicating now Cardinal Timothy Dolan. And I have to ask, is conflict of interest no longer a thing? My experience with the Office of the Attorney General of Missouri makes clear the fact that survivors don't just face the dirty tricks, the lies and deceptions and gaslighting of the Catholic Church and abuse profiteers like Cardinal Timothy Dolan. Instead, survivors have to overcome the system itself, the efforts of men like former Attorneys General and now United States Senators Josh Hawley and Eric Schmidt to protect the Archdiocese of St. Louis and the Catholic Church. Not the people of Missouri. Well, not all the people of Missouri. Finally, the chief objection raised during the House hearing was one of cost to businesses and their insurers. Well, what about the cost to survivors? Do you not think being raped by a priest as a child is a big deal? Cost my family and I are forced to bear solely because the dirty tricks of Cardinal Dolan and the Archdiocese of St. Louis and its lawyers created a problem with the statute of limitations and destroyed the viability of my lawsuit. Costs related to therapy and lost wages and life as a result of my having to deal with anxiety, depression, PTSD, complex PTSD, because when I was a child, I was raped by a priest. To conclude, I'm sure if asked, every member of this committee would assure the people of Missouri they would and will put the people, all the people, before the church, any church. That's what then Attorney General and now United States Senator Eric Schmidt told the people of Missouri in September 2019 in his press conference announcing the results of the investigation of the Archdiocese of St. Louis. But here's the problem. I tried to attend that press conference. I did attend that press conference. I have a document that proves that. And now Senator Eric Schmidt had me thrown out of the press conference and the building for standing quietly in a corner hoping to have now United States Senator Schmidt tell me face-to-face and man-to-man, as Josh Shapiro did in Pennsylvania, what had happened regarding an investigation I participated in. So yes, I've heard it all, seen it all, and all I can say is this: show me. Any questions?
Any questions for the witness? Seeing none, thank you for your testimony. Is there any further witnesses in opposition? Any further witnesses in opposition? Okay, next witness in support. Further witnesses in support?
Thank you. My name is David Clossy. I'm from St. Louis. I'm here because when I was a kid, I was sexually abused for a period of 4 years. Later found out that 3 of my siblings were abused by the same gentleman. One of my siblings went on to become a clergyman himself and went on to molest kids himself. As a result of that, I've been involved in this issue with a support group called SNAP for the past 35 years. My best guess is that I've spoken and listened to and consoled roughly 2,000 men and women who were sexually violated as kids. I'm going to make just two simple points. And the first, the gentleman from the insurance industry says, go after the perpetrators, leave the institutions alone. I'm not a psychologist, okay, but I submit that nothing this body can do will deter a child molester from assaulting a kid, right? These are grown-ups who are sexually messed up. They are operating under deeply rooted psychological compulsions that they cannot control. So nothing's going to stop them. But where this body can make a difference is by enabling victims to pursue justice against not just the perpetrator, but the institutions. Because presumably, these men, their coworkers and their supervisors, they're not compulsively driven, right? They're rational beings. And they know, if this law passes, that they're going to have to screen their employees better and train their employees better. And they're going to have to respond much more quickly and sensitively when abuse reports are made, because otherwise they're going to be dragged through the mud in the news media, and they're going to be dragged into court and face real consequences. So that's where I believe you all can make your biggest impact if you genuinely want to stop abuse, and I believe that you do. Obviously, you're smart people. You know, 1 in 13 kids sexually abused. I submit if 1 in 13 cars sold in Missouri proved to be defective, the legislature would act promptly. The second point I simply want to make is that fundamentally this is really about prevention. As far as I speak to, almost without exception, the first phrase out of their mouths is, I just want to make sure this doesn't happen to another child. The other gentleman in opposition spoke about the convenience of filing a lawsuit. That is not what this is about. There's two ways. If you want to address this epidemic, there's two ways I submit that you can do it. Number one is the public way, and number two is the private way. The public way is if we want to stop child molesters, we can just spend $1 gazillion on more police and prosecutors and better training and more prison guards and all the rest. And that would make a difference if we spend $1 gazillion on that, right? But that's not going to happen, and we know that. So the other option is the private route. And many of us in Missouri, we appreciate people who take initiative. We appreciate people who try to solve their own problems, not getting government help. And we're not asking for government help. We're asking that the courthouse doors that are open to almost all other crime victims just be cracked open a little bit more so that we can go into court and expose not just the people who molested us, but all the others who stayed silent or enabled them. Thank you very much.
Thank you for your testimony. Any questions for the witness? Seeing none. Witnesses in support.
Good afternoon, Mr. Chairman and members of the committee. My name is Ken Chakas. I'm an attorney from the St. Louis area. Been practicing law for over 45 years now. Born and raised in Missouri, lived here my entire adult life along with my wife and children and grandchildren. I attended St. Louis U Law School in the 1970s, and I'm here to testify in support of both Senate Joint Resolution 88 and 64, which expand or eliminate the statute of limitations in sex abuse cases. I think it's very important that the expansion or elimination of the statute of limitations apply not just to the perpetrators, but also to the institutions that allowed and enabled the abuse. A substantial part of my work has been counseling and representing survivors of child sexual abuse. I have worked with over 200 cases and probably consulted another couple of hundred who didn't have viable cases because of the statute of limitations. It's important to remember the reason that victims of sexual abuse are referred to as survivors. And it's simply because many victims had not survived. Some have either succumbed to conditions of drug or alcohol abuse or have taken their own lives. I've represented the parents of children who have committed suicide because of child sexual abuse. Some of my clients have committed suicide during the course of their efforts to seek justice. My clients were abused in schools, churches, and residential facilities such as group homes and hospitals. And I think I've come to learn a lot about the impact of sexual abuse on the victims and their families, and want to share a little bit of that. Many of my clients were abused as children or teenagers, but were unable to tell anyone what happened until decades later. Many survivors told me that I was the first person they ever told of their abuse. Many who were abused by clergy described the fear they felt when they were being abused by a person with seemingly absolute power over themselves and their families. Many were told by clergy that they were chosen because they're special, that God wants them to do this. They were told that this has to remain a secret, and that if they tell anyone, something terrible will happen to them or their parents. Many survivors told me that they thought no one would believe them, and that they would get in serious trouble if they came forward and reported their abuse. Many of them expressed reasons why they couldn't even tell their parents. When they were still children, they believed that their parents wouldn't believe them. To tell their parents something that a trusted individual who was important to the parents did a terrible thing to them, they were afraid that they just wouldn't be believed by their parents, and that they would be punished by their parents. As children got older and more mature, many said that they still couldn't tell their parents because of the emotional harm that it would cause their parents to learn about what happened. Many said they had to wait for their parents to pass away before coming forward, to spare their parents the trauma and guilt of learning that their children were abused by people to whom their parents had entrusted them. So how does all this relate to the statute of limitations? If the statute of limitations is eliminated or extended, much of this trauma and shame and guilt would also be relieved and eliminated. And I think it's important to keep in mind the benefits to society of civil lawsuits. They're not simply a way for an individual to obtain compensation for injuries. They also hold the institutions accountable, the institutions that allowed and enabled the abuse to occur. Civil lawsuits and the threat of civil lawsuits encourage these institutions to better protect children, to prevent more abuse. It's vitally important to extend the statute of limitations, not just for the perpetrators, but for the institutions. There's a House Joint Resolution 129 that's very similar to Senate Resolution 64, right? Is that the one? The one that does provide for retroactivity. The Senate version doesn't apply to the institutions, and I think that's something that either could be amended, or I don't know how you do that, but that's what I would change to the Senate resolution that extends the statute of limitations. Senate Resolution number 88 actually eliminates the statute of limitations. So I think it's important to think about the effect of public disclosure on these institutions. Since the public learned about the vast extent of sexual abuse in the Catholic Church, starting with the Boston Globe Spotlight articles in 2002, church leaders immediately, the same year, across the United States, met in Dallas and adopted a set of policies and procedures designed to stop the abuse. I don't believe they've been effective, but they were on notice that they needed to do something because of the public exposure. And then through the extensive civil litigation that followed, even more light has been shined on those institutions, and not just the Catholic Church, many institutions that enabled known sexual abuse to occur and that actively covered it up. Unanimous decision by the highest court in this state, the Missouri Supreme Court, approved the admissibility of evidence that the Catholic Church developed a code for referencing a priest's sexual abuse of children in their personnel files and other records. The Supreme Court applied the law from what they called an analogous case involving the practices, symbols, and terminology and history of street gangs. That's the case of John Doe versus the Marianas Province, decided in 2021 in a unanimous decision written by Judge Paul Wilson. So exposure of sexual abuse and how it has been allowed and how it's been covered up can go a long way to prevent future abuse and to protect today's children and future children and their families from suffering what's been inflicted by the past abusers. Future trauma can be avoided if institutions are exposed and held accountable for their negligence, their recklessness, and their intentional acts that have covered up the abuse and allowed more abuse to continue. For the survivors themselves and their family members, a major benefit of the ability to pursue a civil lawsuit is to expose what happened, to expose the perpetrator, to expose the extent of the cover-up, and to be part of the effort to protect other people. Survivors who have failed in their lawsuits because of some legal technicality have said that they appreciated the fact that they did it. They were able to tell their story. They were believed, but some legal technicality prevented them from achieving ultimate success in their lawsuit. But they were finally able to come forward and tell their story, and without the opportunity for civil litigation, that it's just not there. So your action in extending or eliminating statutes of limitations can help to continue the effort to let the truth be known, to help the public learn of the extent of sexual abuse, that the cover-up has been intentional and is ongoing. More perpetrators will be exposed, and more victims will be able to disclose what happened to them. Without any change, the cover-ups will continue, more children will be abused, so we must all work to end it. And eliminating the arbitrary statute of limitations is what's before you now. And it should be, as I said, not just for the claims against the perpetrators, but also for the enabling institutions. Thank you.
Thank you for your testimony. Any questions for the witness? Seeing none. Further witnesses in support of Senate Joint Resolution 64.
Good afternoon. Jessica Seitz. I'm the Executive Director of the Missouri Network Against Child Abuse, formerly Missouri Kids First. And my organization just wants to go on the record in support of this legislation. We believe, for many of the reasons the previous witnesses have stated, believe that this legislation and others like it provide another path to justice and healing for those that have survived childhood sexual abuse.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support.
Hello, and thank you for being here today to hear us. My name's Chris Wimmer from Blancheville, Missouri. I was subjected to verbal, physical, and sexual abuse at Chaminade College Prep School in St. Louis from 1970 to 1977. I just hope to share with you from a personal perspective why it's nearly impossible for a survivor to come forward within the parameters of the statute of limitations, and conversely to protect the perpetrators. We've heard a lot of good testimony so far here today. The things that, aside from taking their own lives, things that survivors suffer from make it harder, not easier, to come forward. Lack of self-esteem, included, just make it very difficult. But my personal story started in 6th grade at Chaminade, and within the first weeks of my time there, a teacher molested me in front of a whole room of kids. His first words to me is, "I used to do this with your brother all the time." So this kind of language of, this is okay, this is okay. Some of the abuse, like I said, is in a classroom. Some of the abuse is in a locker room where it's basically public. Just gets into your head and makes you think, well, why should I complain? I don't see anybody else complaining. All these layers of just causing you to keep this down. Again, during my time at Chaminade, I was introduced to, can't remember his first name now, but Father Vondeman, who ran a day camp in southern Illinois. He came to Chaminade to do a pitch to us to come and work for him at his camp. I wound up going to that camp, and one of my friends, I wasn't involved, but one of my friends who went and worked there as well, witnessed Father Vondeman fondling 4 little boys' genitals under the guise of putting poison ivy medicine on them. Later in my career at Chaminade, another group came and pitched to us this Catholic retreat called Teens Encounter Christ. When I went on my Teens Encounter Christ weekend, I met Father Leroy Valentine, who then stalked me for months and months, longer than that. By this time, I was 17 or 18 years old and knew what was up and at least could fend him off. My point being, I'll keep going. At one point, this is maybe when I was 13, I did bring this up to my parents. I certainly didn't tell them I'm being sexually abused. It wasn't graphic. I was just telling them I don't want to be at Chaminade anymore. I hear from my parents, the brothers have a reason for doing what they're doing. Just go back to school and deal with it. I heard other kids whose parents told them similar things. Anyway, so, and then when I did finally, I waited to get married for the longest time because I didn't know if I was a molester. Why would I want to have children? When I did finally meet a wonderful woman and get married, she heard my story and was just like, what? I mean, she was one of the first non-Catholics in my life. That's another thing. I went through college, I went through high school, kind of surrounded myself with other Catholics. That's just the way St. Louis was. This is one of the first people in my life intimately who I shared with who was not Catholic, and she was like, what the heck? We got to go talk to someone about this. Well, by this time, I didn't know about a statute of limitations. I didn't know what the law was. I was way beyond. But at what point are you supposed to know it was wrong, know you were hurt, know the law, and come forward against all these things I've told you that are holding us back, whether deliberately or indirectly. When I did finally go forward, I didn't get an attorney. I went straight to Chaminade. I found a priest who was a friend of my family's and was in my house all the time. I didn't learn until much later that he would bring beer for me that my mom would take away. So this guy was actually trying to groom me years ago. He's the guy I went to as a family friend to tell my story to. And he tried to tell me, I'll just counsel you. You can come and you can talk to me all you want, but let's not go beyond you and me with this. Let's just keep this quiet. When I did go to him 2 or 3 times and finally said, I need to go farther. I got anger issues. I'm in trouble. I need help. That's all I was asking for was help one of your own. So he passed me on to the provincial of the Marianists who lied to me, told me they didn't know about the 2 men that abused me. Please write everything you can remember down and bring that to me so I can hit the ground running with this. You know, there's all these just layers and layers of hold it back, hold it back, hold it back. Anyway, that's all I'm here to say is it was trying to act within the, just knowing the statute of limitations is, you know, what kid knows that? You know, that I need to get an attorney and I need to act within a certain window. Doesn't happen. And then all these emotional externalities that just hold you back, it's an impossibility. And meanwhile, the perps are walking and getting protected. Thank you very much.
Thank you for your testimony. Any questions for the witness? Seeing none. Further witnesses in support? Seeing none, I also want to remind everybody who's testified today so far, if you haven't already, please fill out a witness form and then leave that behind. Do we have any witnesses for informational purposes only on Senate Joint Resolution 64? Seeing none, this will conclude the hearing on Senate Joint Resolution 64. Next up is Senate Joint Resolution 88. Senator Washington, whenever you're ready.
Good afternoon, Mr. Chair and committee, and thank you for having me today. Based on the last witness that I heard from, that was testifying, this bill is very similar. It just simply it removes any statute of limitations for victims of sexual assault or abuse. As you just heard the young man say, it's necessary. We know that sexual victims, rape victims, oftentimes do not come forward ever as children, and so we don't want to give them, 2 years after 18, 3 years, or whatever the case may be. We would like to provide them with an opportunity to stay stable, to be able to deal with that when they are ready and available to open themselves up to bringing those type of lawsuits. And with that, I'll take any questions. I'm sure there's a ton of people in the room that know much more than I do.
Any questions for Senator Washington? Seeing none. We're going to start off a show of hands again. Witnesses in support of this legislation? Okay. Witnesses in opposition? Okay. Looks like there's a lot of overlap, so I just encourage members of the committee, if you have some unique testimony that you want to give on this joint resolution because of the difference in language between the two, that's fine. But just for the sake of the committee's time, and we've got other bills behind this, if your committee testimony is substantially similar to what you gave before, if you could just say that, that would be greatly appreciated by the committee. First up, witness in support of Senate Joint Resolution number 88.
Mr. Chairman, members of the committee, thank you for this opportunity. I'm Dr. McGraw, and I have owned and operated my dental practice in St. Charles, Missouri for the past 42 years. This is my wife, Vicki. I graduated from Melville High School in the St. Louis area, St. Louis University, and UMKC School of Dentistry. My wife and I have been married for 45 years, and we have 2 daughters and 3 grandchildren. I'm here today to ask your support for this bill. We all know that some people do bad things, and if we don't hold them accountable, they and others will continue to do bad things, and society will suffer. And you, ladies and gentlemen, carry the burden of refining the laws that protect us all. In 2017, you all did a very honorable and just thing by removing the statute of limitations for sex crimes moving forward from that date. Our state constitution prevented you from making it retroactive. Our constitution says that it has to be done by a constitutional amendment. So today, all victims of sex abuse prior to 2018 have to abide by the statute of limitations that was in effect at the time, which for the most part over the last 50 years has been 3 years. Now I'm going to tell you why that Missouri law needs to be changed in order to be fair to all. In my research, I discovered a very credible study which stated that the average age that a victim of sex abuse talks to anyone about what happened to them is 52 years, and you heard that earlier. Most victims of sexual abuse are under 25, and the average, so let's just say the average age is 12. That means they wait 40 years before they talk to anyone about what happened to them. Now, I confirmed this with the psychologist, Dr. David Klein, who added that many victims never tell anyone, and they take the secret with them to the grave, as it is too painful and too shameful to recall the memory. Last year, my wife told me about something that happened to her 47 years ago, before we were married. She had kept it a secret that long, which I thought was odd until I discovered the study I just cited. I then realized that she fell comfortably within the bell curve of sexual abuse victims, with the average of 40 years before telling anybody about their experience. A young man whom she was dating in college took her out into remote St. Charles County to see his grandmother's farm, and there he sexually assaulted her. Luckily, he didn't kill her, but took her home and subsequently told her he didn't want to see her again. After she told me what had happened, I researched the statute of limitations for sex crimes in the state of Missouri and discovered there was no longer a statute of limitations for rape or sodomy, so I urged her to report it to the St. Charles County Police, which she did. A few days later, we received a call from the prosecuting attorney informing us that the law pertained only for crimes going forward from 2018 and that the statute of limitations for us had unfortunately expired. That's when my wife and I joined this crusade and found that there were many others who had been fighting this battle as well. We're not involved in this endeavor simply for our own interest, but also for the thousands of victims who have no voice as they have no avenue for recourse. Today, we're not asking you to take a stand. We are only asking you to approve a bill that would allow the people of Missouri to vote on a constitutional amendment to remove the civil statute of limitations retroactively so that all victims of sexual assault have an avenue for recourse. Please vote yes and pass this bill so that the people of Missouri can decide whether or not to continue protecting sexual assault perpetrators or to support the victims of sexual assault by giving them the ability to legally pursue their offenders. That's my prepared statement. I have a couple things I'd like to add to it. Why does it take so long for these victims to come forward? Well, I talked to Dr. Klein about that, and he explained something to me. He's a psychologist. He said, when you're in a situation like that, your cerebral cortex shuts down. Your cerebral cortex is the big part of your brain that does all the analytics and makes complicated decisions. But when you're in a fight or flight victim, and Dr. Klein, his specialty is treating war combat veterans who suffer from PTSD. And they're in very horrific situations. But what he explained is that your cerebral cortex shuts down and the primitive brain, your spinal cord, medulla oblongata, and all that stuff takes over. It's the fight or flight thing that kept us alive 50 million years ago. So you're not thinking normally, and this part of your brain is meant to keep you alive, and it tells you what you're going to do. Many people don't think about it, they don't process it because it wasn't processed by their cortex, it was processed by their primitive brain. And they are ashamed of what happened, and they wonder, well, why didn't I fight back? And I asked Dr. Klein, why? And he said, because that primitive brain makes a quick judgment as to whether fighting is going to get you out of the situation, or whether cooperating is going to get you out of the situation, or running is going to get you. One of those three choices, those are your choices. And he says, the primitive brain makes that choice, you don't. And in my wife's situation, the primitive brain said, cooperation is the best way to get out of this. The other thing I wanted to bring up, I ran across a college study. This was in PubMed. If you're familiar with PubMed, scientific studies that are very well vindicated. And there were two studies I found. One was college men who admitted to sexually abusing women in college. And they found that 26% of college men actually admitted to abusing women while they were in college. Then I found another study which was very interesting. It was about college women who had been sexually abused in college. And 26% was the amount of women who had been sexually abused. Exactly the same number, two different studies. That's all. Thank you.
Thank you for your testimony. Any questions for the witness? Seeing none. Thank you for your testimony. Further witnesses in support, Senate Joint Resolution 80, I'm sorry, witnesses in opposition. I forgot we've got a couple witnesses in opposition.
Members of the committee, Rich Aubuchon for the Missouri Civil Justice Reform Coalition in opposition to the legislation. Repeating the comments I've had from previous legislation that we've heard before the committee with one other comment. I have stated in the past in the House committee in a very similar issue dealing with the cost. Let me just talk about what I meant by that because it was mentioned in previous testimony. Here's my comment. Not every employer is a bad employer. And so what we're doing is drafting legislation to cover all employers, all perpetrators. And so what I'm getting at is this. There are terrible employers out there. We get that. I wish we could craft a bill that only addressed those terrible, horrible people that work for companies that perpetrate the same things. That would be a special law. Unless we come up with something so creative that frankly, it would be unworkable. What I'm getting at is this. The vast majority of small babysitters that work out there, daycares, et cetera, that we rely upon to have a business environment that we can go to work, rely upon having insurance to ensure that they are able to insure the people that are there and also protect from liabilities for these types of things. If you create an environment as a statute that covers all employers, I believe that you'll create an environment that will make insurance so expensive that you won't be able to have coverage for those people, or it'll be something that's so expensive they won't be able to afford it, which is a necessary component of actually having recovery for these people, right? So don't create an environment that is punitive for all employers in a situation where they won't be able to have coverage to actually make the people whole who have been harmed. I believe that in situations where states have done this, we've also seen a response from the insurance industry not to offer coverage or to make coverage very expensive. And you have to make a decision as an employer not to be able to take that coverage or have riders that cut that coverage out, exclude it. I don't think that's necessarily beneficial for either the victims or for the employer. So that was my comment. I want to make sure that we have that on the record.
Any questions for Mr. Aubuchon? Seeing none, thank you for your testimony. Further witnesses in support of Senate Joint Resolution 88.
Thank you, Chairman and members of the committee, and thank you for introducing this bill. Again, my name is Catherine Robb. I'm the Executive Director of Child U.S. Advocacy, and I'm testifying in support of SJR88 that modifies the statute of limitations for civil claims based on certain sexual offenses against children, but only to the individual perpetrator. Failing to hold institutions accountable is a serious threat to all children. Again, institutions do not change their ways until they are held accountable, and we see this time and time again, and institutions generally don't get filtered through the criminal system, nor do they spend time in jail. I would like to address what was just mentioned on insurance. I do believe, and I've testified on this in other places in the country, that really the insurance industry really needs to get on the right side of this issue, which of course is not before this committee. However, just like auto insurance, if you are a bad driver and you speed or you drive drunk and all of those terrible things, your insurance policy goes up. And if you continue with that behavior, you're not insurable, and therefore you can't drive. Well, the same thing should happen to institutions, and those institutions that follow good policies, procedures, hiring, training and reporting and not concealing sexual crimes against children, there should be audits. And if you don't have good policies, procedures, and training and all of that, then you don't get insurance. And we all know that businesses can't survive without insurance. So there isn't an issue, a proper response to that on that issue. I just want to also point out a few things that I did not mention in my earlier testimony. Statute of limitation reform serves three purposes. First, it educates the public about the ubiquitous nature of this epidemic, and it is an epidemic. It also shifts the cost, and I know I mentioned this just briefly, it shifts the cost away from victims and their families to the bad guys, where it belongs. But I think the most important thing that revival legislation only for child sexual abuse claims, the most important thing that it does is that it exposes hidden sexual predators. It saves and protects children now and into the future. It's not just about opening the doors to the courthouse for those victims, which I do believe we should do, but it's about protecting children in the future. I want to point out that many jurisdictions, 14 so far, have had rulings on this type of legislation and have ruled that they are in fact constitutional, that there's a compelling state interest for the legislative body to change these laws to protect their children. There are also many other jurisdictions, Colorado being one of them right now, that have amendments to do the very same thing. You know, as we know, that every state constitution is a little bit different, right? So we do have that happening across the country, again, in response to this epidemic. I would like to also just touch on due process for a minute. When I heard the need for finality, well, I asked this committee, why should sexual perpetrators be protected by the passage of time when victims suffer in perpetuity? That it just isn't good public policy. It's not reasonable. It doesn't make any sense. You don't need to go to law school to understand that, right? They shouldn't be protected while others suffer. And I would also like to add that there are some wrongs that have no statute of limitations. And it makes sense. It's good public policy. It's reasonable. It's fair. It's just. Right? So we do make those exceptions. All of our laws have exceptions, and some of those exceptions have exceptions, but they're all based on sound public policy, reason, justice, common sense. And we believe that protecting children is a really good reason to change those. Just a few more comments, if I may. I'm a mother of 5 children. Last year, my oldest son, and I'm an expert on this, my oldest son, who you can see in this photo, was about 9 years old in his Little League uniform, came to me at age 30. And he told me that when I and my then husband took him to an ER, he was very sick, and I remember this, that the doctor who told us as his parents that he was taking him for a test took him to the basement of this very well-known hospital in the Boston area and sodomized my perfect, beautiful 8-year-old son. Yet still, it took my son until he was age 30 to come to me and to talk to me about this in a bucket of tears. When the founders of the Missouri Constitution, well over a century ago, I think it may be a century and a half if my history's right, when they drafted the Constitution, they didn't know about this epidemic. They didn't know about delayed disclosure and trauma. And certainly in 91 or 2 and my son was sodomized by a doctor who I trusted, I also didn't know. I didn't know about Jerry Sandusky. I didn't know about Kanakuk Camp. I didn't know about Larry Nasser. I didn't know about the clergy abuse. I didn't know about any of that. And I would say that nor did you. But we do now. We know now. And I think that now that we know, we have a duty to change. But again, the framers didn't know this, right? And so I think now is the time to change. This is fair and reasonable changes to protect our children. I do have a suggestion for a slight edit on the legislation, and I'm happy to talk to anyone about that. It's only 2 words. But I think it's time, based on the knowledge that we know. And I thank you for giving me this opportunity to testify, and I'm happy to take any questions.
Any questions for the witness? Seeing none, thank you for your testimony.
Thank you very much.
Further witnesses in opposition to Senate Joint Resolution 88?
Mr. Chair, members of the committee, Michael Henderson for the Missouri Insurance Coalition in opposition to this bill. I think, as Mr. Abshan pointed out, certainly the acts of some of these institutions are deplorable. I think certainly, as was already pointed out, the challenge you run into is trying to craft something that's not so broad that it brings in, really the majority of our businesses that are not bad actors. I would think when the founders of our Constitution instituted the prohibition on retrospective laws, they knew what they were doing. There's policy reasons why we don't have retrospective laws. Certainty for one, due process for another. The analogy on insurance, I think certainly from a prospective nature, perhaps there's a little bit of analogy there that can be drawn, but I will point out that when you expand the statute of limitations 15, 20 years, in the case of some of the legislation we've heard today, in perpetuity, that's going to have an effect on costs to small businesses across the board, setting aside even risk. Certainly there's a number of programs, safety programs. We see that in the work comp side. We see that in training for sexual assault as well, that I think a number of businesses do utilize and can ultimately affect the risk profile. But to say that there's a 1-to-1 on the auto difference, certainly I would disagree with that. And I think that analogy certainly doesn't hold up when you start talking about retrospective laws, for sure. Now we're getting into acts that occurred in the 70s and 80s. Some of which may have been insured, some may not have. When those policies were sold, they were sold under the mores of the day, right? The common understanding of the day, whether or not those risks were contemplated, whether they were contemplated and set, based on the statute of limitations and the laws of the day. Those are all hard questions to answer sitting here today, and I think that's one of the reasons why retrospective laws, there's a policy against those generally. So for the reasons already stated, previous witnesses in opposition, and then also, based on my testimony, we oppose, but happy to answer any questions.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support, and we're going to try to limit witness testimony to 2 minutes a witness, just because we have 2 additional bills behind this. So if witnesses coming forward on both sides could limit their testimony to 2 minutes each, that'd be greatly appreciated.
Thank you again, Chair Luetkemeyer. I'll be brief, but wanted to add some additional context from testimony on the prior joint resolution. Thank you, Senator Washington, for authoring this important resolution to go after child predators. To me and so many who will testify in favor of this issue, it is personal. My late brother, Trey Carlock, endured a decade of abuse at Kanakuk camps in southwest Missouri. They've had a decades-long history of child sexual abuse that's finally gaining more traction in local and national media. And we now know, as the Kanakuk survivor community, of 200 victims spanning from the 1950s to today, with allegations against 60 unique perpetrators. Most of these are still at large due to Missouri's current antiquated statute of limitations. We're hopeful that this legislature wants to do something about that. My brother was abused by Kanakuk executive and super predator Pete Newman, who remains in prison for 2 life terms plus 30 years here in Jefferson City. Newman is one of the most prolific super predators in modern American history, with a prosecutor estimating a victim count in the hundreds and clinicians saying thousands. We came to summer camp in Missouri and we left with lifelong trauma. To be clear, Pete wasn't the only one who abused my brother. Trey was abused again by Kanakuk and its agents who harassed and gaslighted him in a re-traumatizing legal process that ended in a settlement achieved by fraud, which also included a restrictive NDA. Not just his innocence, but his voice was stolen too, and he is sadly one of many John Does with this story who cannot be here today because of NDAs. Quick recap on the current statute of limitations in Missouri for child sexual abuse and trafficking victims. This state currently requires victims of child sexual abuse to file civil action against a liable institution by the age of 26 and a direct perpetrator by the age of 31. Those numbers are arbitrary and not based on research. They are due to insurance lobbyists seeking to limit their clients' liability. It's time for a reckoning in Missouri, and institutional accountability must be part of SJR88 or it falls short. Just putting a bad guy away through criminal prosecution does not cover the lifelong cost of trauma treatment. A national expert has testified that the average age of disclosure for child sexual abuse victims is 52. You've also heard there's a national movement to respond to this data through constitutional amendments that allow for revival windows, such as what SJR88 proposes. Missouri's in the bottom of 6 states in the U.S. on this issue. They get an F grade from Child USA alongside Alabama and Mississippi. Arkansas just extended their 2-year revival window for another 2 years because they want victims to be able to hold child predators to account in civil courts at any age, and that's what's in the public's best interest. So I think you'll agree that it's time to stop the clock for child sex abuse survivors here in Missouri. Don't rush them into civil litigation like my brother. A short statute of limitations can be lethal, as my family knows, and another form of rape. Sadly, a lot more has come to light since my brother's death. It's all in the legal record. Kanakuk knew of Newman's felonious behavior at least a decade before he confessed, and there are scores of other Kanakuk-affiliated predators other than Newman who are well out of statute. So their only recourse has been to go to the media and bravely share their stories with media outlets like Branson Tri-Lakes News, St. Louis Public Radio, and the Springfield News Leader. Many abusers were shuffled around and allowed to continue their employment at Kanakuk-affiliated ministries like K-Life, Kids Across America, and others. These criminals could have been stopped, still can be stopped, if there is a revival window enacted in Missouri. The problem persists until this legislature takes action. I hope you can see this systemic injustice makes Missouri a sanctuary state for pedophiles. Bad actors intentionally operate while they'll have the least liability and regulation, while victims never imagine they're on a deadline. Let me leave you with the reminder that April is Child Abuse Prevention Month. We're calling on you to prioritize the safeguarding of kids in a way only you can. You have the power to propose an amendment to the Constitution. Victims do not have that power. Please remember my brother Trey. Let your courts hear these cases. Until then, Missouri is not safe for children. Thank you.
Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support?
My name is Douglas Lay. I wasn't going to share, but I felt compelled. Several years ago, I was a whistleblower at my home church about sexual abuse cover-up. Within a month, they hired lawyers to sue me. They did sue me, to silence me. About a year later, I was a whistleblower at a Christian college I used to work at, considering students who would come forward that they had been assaulted and abused. And within less than a month, the college had hired lawyers and threatened to sue me if I spoke out. And I thought about, these are institutions that have access to the law and they have money for one main reason, because they are protecting their institutions, driven by their insurance companies so that they won't lose money. As you heard, victims, and I'm a victim also, we don't have the money. Typically, and we surely don't have knowledge of the law. So if we're gonna, I spent over 40 years before I shared. If we're going to spend 20, 30, 40 years before we come forward and not have the resources, and I thought the irony that victims don't have the resources, and why 2 institutions, a church and a college, had already within a month, less than a month, hired lawyers to sue us to be quiet, tells you the impact of lawsuits. If the statute of limitations are, I mean, you don't have any, I mean, you have them, then of course they can relax. So they just have to endure until the time runs out, and then they're relaxed. Limiting the statute of limitations forces these institutions to have to deal with this. Thank you.
Thank you for your testimony. Further witnesses in support?
60 seconds, if I may. David Clossy again from the Survivors Network of Those Abused by Priests. I've had the pleasure and privilege of testifying in somewhere between 12 and 15 legislatures around the country on this very issue. So I've heard many times, I've heard the Mr. Aubuchon's, and is it Henderson? Mr. Henderson's, 3 things we don't ever hear from them. There are 30 states, 30 jurisdictions that have extended or eliminated these statutes of limitations, as Catherine Robb told you. 30 states. Why do we never hear the studies that supposedly bear out these awful consequences? We don't hear a study saying false claims have gone off the charts in these other states that have done what we're asking you to do. We don't see the studies. We don't see the witnesses. No witnesses showed up today saying, by golly, my little old business, now we can't get insurance because the lawmakers in my state reformed the statute of limitations. We don't see any of that. So you've got to balance 2 simple things. You've seen and heard from real live human beings that have suffered immeasurably and continue to suffer. That's reality versus these theoretical, the sky is going to fall, the sky is going to fall. So I would ask you to consider very seriously the real life consequences of sexual abuse. Thank you.
Thank you for your testimony. All the witnesses who are testifying on both pieces of legislation, just be sure that either your witness form is filled out for both or that you submit 2 separate witness forms. And the prior witness, I know you had said that you didn't originally intend to testify, so if you did not fill out a witness form, please do so. Further witnesses in support?
Thank you, Mr. Chairman, members of the committee. Tricia Workman here today on behalf of the Missouri Coalition Against Domestic and Sexual Violence. Our member agencies deal with many individuals who'd benefit from this. We want to thank you for listening to the testimony and the Senator for bringing it forward. Be happy to answer any questions.
Thank you, Trish. Any questions? Seeing none, thank you for your testimony. Further witnesses in support?
Hello again, Jessica Seitz, representing the Missouri Network Against Child Abuse, and just want to go on the record in support of this legislation.
Thank you. Any questions for the witness? Seeing none, thank you for your testimony. Further witnesses in support? Seeing none, any further witnesses in opposition? I don't think we had any. Seeing none, any witnesses for informational purposes only? Seeing none, this will conclude the hearing on Senate Joint Resolution 88. Next up, we're going to go ahead and hear my bill. I'm going to turn it over to my vice chairman for the committee. And I'm going to say this before we go down. This is a bill that the committee is very familiar with. So brevity in testimony would be greatly appreciated by the chairman. Next, I know we've got Senator Thompson Rader's bill that we're hopefully hear as well before we go into session.
Moving to Senate Bill number 853, Senator Luetkemeyer, please take the bench, the stand, whatever that is, and begin when you're ready.
For the record, Senator Tony Luetkemeyer, representing the 34th Senatorial District, here today to present on Senate Bill 853, the Statute of Limitations Bill. What this bill does very simply is it takes Missouri's 5-year statute of limitations for personal injury cases and reduces it down to 2. Missouri has one of the longest statutes of limitation in the country for personal injury cases. 2 or 3 years tends to be the national average. This brings us in line with what other states do. It also lowers the time frame for filing a claim for uninsured and underinsured motorist coverage from the current 10-year period down to 2 years. The purpose of a statute of limitations is to provide predictability to the parties, also to make sure that evidence is reasonably available as time goes on, witnesses' memories fade, and access to physical and documentary evidence becomes more difficult to get. This encourages parties to quickly resolve their cases and stops a backlog of flooded cases in our courts. And with that, Mr. Chairman, I'd be happy to answer any questions.
Briefly, the one witness that was in here talking about studies, on this one, how many other states have restricted the statute of limitations to roughly 2 years?
So, like I said, the majority of states in the country have either a 2 or 3 year statute of limitations. Missouri being at 5 makes us, I believe, the second longest statute of limitations in the country. I think there are maybe 2 or 3 states that have longer statutes of limitation than we do in Missouri. I believe also this retains the provision from last year where we did a carve out for sexual assault cases, and so the bill as filed would not lower the statute of limitations for sexual assault cases like the cases involving the testimony that we heard previously.
And I know we're going to hear, from both sides. Do you have any studies on either where, the states that have restricted it, the insurance rates have actually dropped? Because I know we're going to hear that if we continue it like this, insurance rates will go up. And conversely, do we have any studies on how this has impacted the access to the courts or any flooding of the courts? Because if you have people that are still treating, they're going to ultimately have to file.
Yep.
Well,
2 separate questions. So when I spoke, I didn't talk about insurance rates. My guess is that it would have some impact on insurance rates, just because the risk of a lawsuit being filed would be greater, and so I assume that would go into the actuarial calculation for the insurance company. That said, I believe we have a couple of representatives from the insurance industry. They're probably going to testify on that topic. So in terms of studies, I would have to defer to them.
Any further questions? Seeing none. First witness in support, you were limited to 5 minutes. Please come forward, have your witness form ready, and begin when you deem necessary. Thank you.
Good afternoon. My name is Dana Fries. I'm president and CEO of Healthcare Services Group in Jefferson City, Missouri. We insure 58 not-for-profit hospitals throughout the state and approximately 2,000 physicians and thousands of allied providers, nurses, and the like. We provide both professional liability and general liability insurance for our insureds. I'm testifying today on behalf of the Missouri Organization of Defense Lawyers and the Missouri Hospital Association. As noted by Senator Luetkemeyer, statute of limitations aim to ensure that evidence is fresh and reliable for both parties, and that defendants don't have the threat of litigation hanging over their heads for an excessive amount of time. Missouri's 5-year statute of limitations for bodily or personal injury claims is one of the broadest in the United States. Permitting an individual to file a bodily injury lawsuit 5 years after an accident is fundamentally unfair to the defendant. During the span of 5 years, there is a substantially increased risk of evidence being inadvertently destroyed or misplaced, and certainly witness memories will fade. Further, some evidence becomes stale over time. In terms of attracting business to the state of Missouri, Missouri's 5-year statute of limitations puts our state at a competitive disadvantage. Our neighboring states have the following statute of limitations for general bodily injury claims: Arkansas, 3 years; Illinois, 2 years; Iowa, 2 years; Kansas, 2 years; Kentucky, 2 years; Nebraska, 4 years; Oklahoma, 2 years; Tennessee, 1 year. 47 states have a statute of limitations shorter than Missouri. 25 states currently have a general statute of limitations of 2 years, the time frame proposed in Senate Bill 853. Missouri's 5-year statute of limitations hasn't been amended since 1939. I think we all would agree that we live in a very different world today in terms of communication, access to the courts, and certainly access to legal counsel. Requiring lawsuits to be filed within 2 years is better on balance than being subject to suit later in time when legitimate defenses are more likely to erode. Both the plaintiff and the defendants are entitled to a right to a jury trial under Missouri law. In fact, defendants are sometimes unaware of an accident having occurred until the sheriff shows up and serves them with lawsuit papers. To avoid flooding the courts and avoid an unnecessary filing of lawsuits, my organization routinely enters into tolling agreements with plaintiff lawyers where if we're working on trying to settle a case and the statute of limitations is approaching, it makes sense for both sides to enter into a tolling agreement so you can continue to have discussions, and most of the time a settlement is reached and the parties go on their way. In my view, Senate Bill 853 strikes a reasonable and fair balance from a public policy standpoint by imposing a 2-year statute of limitations. I therefore request that this committee vote in favor of Senate Bill 853 and be happy to entertain your questions.
Thank you for your testimony. Would you be interested in, and that was one of the questions I was going to ask for those that are negotiating in good faith or those that are still treating, would there be any type of amendment that you could put in this language to account for that, to solidify that in law, that if somebody's still treating, and they're approaching that statute of limitations, my fear is that they'll quickly jump to file a lawsuit that otherwise could have been settled?
I think the current system works pretty well. If we have people that are treating, they want to try to resolve the case, but the statute of limitations is looming, to enter into voluntary tolling agreements. We've also had cases where a lawsuit's filed, both sides agree, let's hold off on discovery, let's exchange information voluntarily and see if we can settle the case. I mean, there's all the motivation in the world for me to want to do that. Most of the claims are settled in some form or fashion. Very few cases actually go to a jury trial anymore. So I'm certainly a proponent of finding ways to avoid trials if we can and settle cases reasonably if both sides are willing to do so.
Yeah, that's always been my apprehension with some of these bills, is that, in this type of industry, would it be fair to say that the majority of the cases, the majority of the cases actually settled before litigation is filed? Would that be fair to say?
Yes.
And that again is going to be my fear, is that if we shrink that period, you may, and I don't know if anybody has studies on, states that have gone from a statute of limitations similar to us to a 2 or 3 year, what impact has that had on the flooding of the courts? And I know in St. Charles County, St. Louis County, in my area, we've got some massive dockets right now, and I think the impact that could have on the caseload could impact not only the personal injury side, it could, tack on more wait times for domestic and criminal law as well.
Well, and certainly the problem we have in comparing studies in Missouri to other states is our neighboring states have had their statute of limitations short for an extended period of time. We've been the outlier for so long, it's really hard to compare. What I can tell you is when I talk to our actuaries and I talk to our reinsurers, they keep asking me, well, why does Missouri have a 5-year statute? And what that does is that builds in conservatism in their rating model. And the insurance rates that I charge have to be actuarially supported and sound. And so a broader statute of limitations is just going to add conservatism to the equation, and that keeps the rates elevated. And I'm very confident that we can manage a flood of the court system. We had a bit of a spike in lawsuits that were filed back in 2015 when we had some medical negligence tort reform. We worked through that. It didn't result in huge delays.
Now, do you think there will be a spike in suits filed?
I think there will be some cases filed because a statute of limitations is reduced and you have a transition period. But like I said, with 2015, we worked through that transition period. It is not an issue now, and I think it will be very manageable. And what it does because it's manageable, it puts Missouri on a much more even playing field in terms of business and industry going forward, and it also permits us to keep our insurance rates more competitive with other states in terms of drawing industry to the state.
My last question, I know we're short on time. What's the analysis with insurance rates in Missouri versus our neighboring states? Are we much higher or are we competitive?
Depends on what state you're talking about. In terms of Illinois, although they have a shorter statute of limitations, they don't have a non-economic damage cap, and they have certain other components to their environment that make it not very competitive. In terms of insurance rates for a state like Kansas, they have definitely advantages that we don't have in Missouri. So it depends on what state you're talking about.
Any further questions? Seeing none. We're going to switch to members or witnesses against. You're going to be limited to 5 minutes. Please come forward. Make sure you fill out a witness form. Proceed when ready, and then all witnesses thereafter will be limited to 2 minutes.
Good afternoon, members of the committee, senators. My name is Randy Alborhaski. I am a personal injury and workers' compensation attorney from Springfield, Missouri. I'm here to testify against Bill 853. Let's not sugarcoat this. The purpose of this bill is to save insurance companies money by depriving people of their constitutional right to jury trial. Plain and simple, that's it. It will employ more attorneys. It will deprive people of their right to a jury trial, and it will prevent people from making recovery on insurance policies that they paid for, underinsured policies, uninsured motorist policies. I've been doing this for 30 years. I can tell you that no one walks into my door wanting to sue someone. They come in to see me, probably the first attorney they've ever hired, because they're hurt and they want to get better. That's the first thing they tell me. I want to get better. I want to get over this. And I tell them, well, we can't do anything until you do, until you start to recover, until you've gone through your treatment. And that's a long process. That takes time. Physical therapy, MRIs, scheduling a doctor's appointment these days. Have you tried to see a specialist? Last time I scheduled a specialist, it took 3 months, and then my insurance company canceled on me and I had to reschedule it. So if you end up doing conservative care, as we all recommend, for a number of months, and then they decide to do surgery, and then you're looking at another 6 to 9 months recovering from surgery, you're already looking at 2 years or more before you're ready to even determine what your injuries are, what your damages are, and try to discuss settlement in the case. So I think 2 years does nothing but provoke or cause attorneys to file lawsuits. As a work comp practitioner, we already have a 2-year statute of limitations for work comp claims, and the first thing I do when someone walks in my door is I file a claim because I don't want to mess with that statute of limitations. I don't want to commit malpractice. And that's what will happen in personal injury cases. Lawyers will file lawsuits. So who gets hurt by that then? Not the people who hire attorneys, the people who don't. The people who are scared to file lawsuits, scared to see an attorney, just want to get better, are uncertain about pursuing their rights under the law, they will be penalized because they are justifiably concerned and not wanting to be litigious, which is what I think we all want in our people. So the byproducts of this statute as written are twofold. You'll have more litigation, you'll need more judges, you'll need more judicial system, and you'll also slow down what system we have in place right now for the criminal process, people seeking trials, trying to, rape charges, murder charges, all those will be affected by the overload of the system. There was mention, I think, earlier about tolling being an issue or perhaps a solution to the problem. Again, as an attorney, I'm not going to agree to not file my lawsuit. I'm going to file it because I don't want to mess with agreement to toll the lawsuit. People who are going to be affected again by that are people who don't hire attorneys, who wait too long and after 2 years still trying to recover, go talk to an attorney and then they're barred. And that happens on a fairly regular basis. People are put off by insurance companies. They trust them to negotiate in good faith, and that doesn't always happen. And it does happen where, unfortunately, people are put off long enough where they are barred by the statute of limitations because insurance companies aren't acting in good faith. That part of this statute, as proposed, seeks to limit underinsured motorist policies and uninsured motorist policies from coverage from extending past 2 years. That in itself is an extremely onerous limitation in that we cannot file a lawsuit for uninsured motorist coverage until we have a judgment against the party proving that they're uninsured. And that, I assure you, takes longer than 2 years in the vast majority of cases. So the statute as written will preclude people from recovering on uninsured motorist coverage because they can't get the judgment against the uninsured defendant in time. I don't think that's the intended consequence of what we all want. The third, or the other unintended consequence of this bill will be to push the cost of medical care onto Medicaid, onto Medicare, and onto health insurance companies because they will no longer be getting recoveries from these lawsuits where we represent people who have insurance through Medicare or Medicaid or through their private health insurance, and we recover as a result of that. In other words, whenever I represent someone who has Medicaid or Medicare or a private health insurance company, I have to make sure they get paid back.
Just a couple more seconds to wrap up.
If I can't do that, then that burden is going to be put on the state. That's all I have. If there are any questions.
Any questions? Seeing none. Thank you for your testimony. Next, in favor of the bill, please come forward. You're limited to 2 minutes. Make sure you fill out a witness form, even if you testified on the other bills today.
Mr. Chair, members of the committee, Michael Henderson for the Missouri Insurance Coalition in support of this legislation. To answer your question about a flood of the courthouse, Senator, you know, I don't think we're creating any new number of claims, any new number of injuries, right? And so as Mr. Freeze pointed out, maybe initially you might have a few more lawsuits get filed, but I don't think you're going to create a flood. You know, we heard from witnesses in support of the prior bills today that expanding of the statute of limitations certainly doesn't cause a flooding of the courthouses, and I don't think you'd see that in this case. Just to touch on a couple things too, I think what we're trying to do here is just bring the balance back, right? For Missouri, we're obviously an outlier. Most states are at 2 or 3 years. For a company, a business, an insurance company, there are often times where we don't even find out about an accident or an injury or a lawsuit until year 4 and 6 months. While that whole time, plaintiff's attorneys certainly had the opportunity to know about the injury, where it occurred, the damages, do investigations, and we're finding out year 4 that something happened 4 years ago that we're just becoming aware of. So swinging that balance back to bring us in line with other states makes sense. On the UM/UIM component, that is at 10 years currently. It's a contract statute of limitations. We've treated UM/UIM claims the same as personal injury claims in the past, most recently for purposes of venue with Ed Emery's Senate Bill 7. There are 25, about half of the states, I believe 24 or 25 states, their UM/UIM statute of limitations are at 2 or 3 years. I believe there's 20 states in the country that have the same UM/UIM statute of limitations as personal injury statute of limitations. That's either set by statute or by contract. Missouri's one of 3 states that has a 10-year UM/UIM statute of limitations. In many states that have a longer one, such as Ohio, some others that come to mind. If they have a longer UM/UIM statute of limitations, those states allow companies to lower that to the personal injury statute of limitations by contract. We can't do that here in Missouri. Missouri does not allow changing or modification of statute of limitations by parties by way of contract. Even if you would want to contract to lower statute of limitations or raise it, you can't do that by contract here in Missouri. So we think this makes sense to bring them down, and it will help us also in cases where personal injury statute of limitation or personal injury cases are not filed to preserve an individual's right, to that claim will help us preserve our subrogation rights on those UM/UIM claims.
First, brief question. I know we can talk offline as well since we're limited on time. If we know these, it's more than likely going to increase the cases that are going to be filed. In those instances, that's basically one of the only ways to file a case that you can go above those policy limits. So looking at the chances now of a case being filed are increased. So the chances of going beyond the policy limits are increased. Is this going to have any impact on the rates for the insured?
Well, to the first point, I'm not sure that we do know that it's going to increase. Just as it was pointed out in the previous bills about the lack of studies, the opponents to this bill over the years have not come forward with any studies that would show that a reduction in statute of limitations does raise or increase claims. To the second point, for companies like those that I represent, if you find out in year one that a claim has occurred, a possible suit may be filed, we have to set aside reserves on those claims for, up to and including 5 years until and unless a claim is filed. And then that money can come off the books, right? And so I think just from that sort of administrative standpoint, that overhead standpoint, I think it would help to lower costs. Certainly, we see a number of issues in the homeowners market, the general liability market, storms, inflation, that are raising costs in some states, in some cases 30-40%, that have nothing to do with personal injury cases. And so certainly I think any time that a company has to incur costs in year 4, finding out for the first time that a case has occurred, or incur costs by carrying reserves for much longer than you have to in other states, that certainly doesn't help lower the cost. And I think anything we can do to help foster, as Mr. Freeze pointed out, a good environment to do business, whether you're a business or an insurance company, would make sense.
Further questions? Seeing none. Thank you for your testimony. We're going to go back to those in opposition. Please come forward. Limited to 2 minutes. Anyone in opposition? Seeing none. Going to go back to those in favor. Please come forward, fill out a witness form, proceed when ready.
Rich Abishan on behalf of the Missouri Civil Justice Reform Coalition, supported the bill.
Any questions? Seeing none. Next in favor, please come forward, fill out a witness form, proceed when ready.
Mr. Chairman, Brad Jones with the NFIB, and we've supported this bill for several times, actually, so thank you.
Thank you, sir. Any questions? Seeing none. Next in favor, please come forward.
Larry Helms from Missouri Canoe and Floater Association, and as a businessman, I rise in support of this bill. And a couple reasons that I want to bring up, and I'll try to be brief. The purpose from my chair is that statute of limitations to protect would-be defendants from unfair legal actions, primarily arising from the fact that a significant passage of time, relevant evidence may be lost, obscured, or not retrievable in the memories of witnesses available and may not be as sharp. In my experience, in some cases, the business owner is blindsided, is not aware an injury that is being alleged occurred at his or her place of business. Not being aware of an injury that alleged occurred allows the defendant no time to document the scene, complete an incident report, talk to police or whatever, and document witnesses in support of defense, especially after several years has gone by. with that, I have a listing of other states that have that have been through this process and has lowered their statute of limitations. For example, Kentucky has a 1-year statute of limitations for injuries. I can also tell you that looking down through here, Tennessee has a 1-year statute of limitations. And 24 states have a 2-year statute of limitations that they have gone through this, and they seem to make out quite well, taking care of the plaintiff and the defendant. We are one of the, I think if looking down through the list, there's only one other state that I see, Maine, that has a 6-year statute of limitations. So from a business standpoint, it is a positive thing for us to take care of the people that got hurt, but also take care of the businesses in the state that would be well served to allow them to be able to gather evidence, talk to witnesses in a timely manner, because I know of one business right now at the Lake of the Ozarks that has been, they just got the summons to go to court. This business had a person come and said there was a slip and fall at their business 4 years ago. They have no record of this person ever being at the business. They have no record of no incident reports, no police reports, no ambulance reports, nothing. And now they have got to try to figure out a defense against
Just a couple
this.
more seconds, sir.
A lot of times people, because the business will, insurance company will settle because the business is unable to bring up a defense because they have no record of people being there. So one other quick thing, there are some inherent risk laws on the books for it's like camping, floating, stuff like that. In those laws, there is specific things that has been spoken about that are inherent risks, but it's not all inclusive. So some other things that may be brought up as far as injury cases that are not covered in the current law.
Sir, this is going to have to conclude your testimony. You're free to contact any of the other members. Any questions of this witness? Seeing none, next witness, please come forward.
Thank you very much.
Thank you.
Mr. Chairman, members of the committee, Bill Gamble, Missouri Railroad Association support.
Any questions for Mr. Gamble? Seeing none, next witness, please come forward.
Mr. Chairman, members of the committee, Ray McCarty, Associated Industries of Missouri, and just like to go on record in support and point out 43 other states have figured it out, how to do it with 3 years or less. We can do it in Missouri. Thank you.
Thank you, Mr. McCarty. Any questions? Seeing none, next witness, please come forward.
Mr. Chairman, members of the committee, Nikki Strong on behalf of American Tort Reform Association in support.
All right, any questions? Seeing none. Next witness.
Mr. Chair, members of the committee, Heidi Geisbuehler-Sutherland, here on behalf of the Missouri Chamber of Commerce and Industry in support.
Any questions? Seeing none. Next witness.
Mr. Chair, members of the committee, Kaina Iman on behalf of the Missouri Association of RV Parks and Campgrounds. I think Mr. Holmes stated our concerns.
All right, any questions? Seeing none. Next witness.
All right, Mr. Chairman, members of the committee, Ben Travelis, Missouri Farm Bureau, want to go on record in support.
Any questions? Seeing none. Any further witnesses in favor? Any against? Informational purposes? Concluding remarks.
Thank you, Mr. Chairman.
All right, that concludes the hearing on Senate Bill 853. We're going to now move to the last bill, Senate Bill 1451. Do we have time? How quick can you be? How many are in the audience for Senate Bill 1451? We have one. I think we can limit testimony, and let's jump on this and proceed when you are ready.
Thank you, Mr. Chairman, members of the committee. I'm Senator Holly Thompson Rader from Southeast Missouri. This bill, the first portion of this bill, basically this bill is trying to include our fentanyl and our carfentanil so that our law enforcement can actually hold traffickers accountable. And the first part of this bill, the offense of endangering the welfare of a child, this was brought to me actually as a priority of the governor and something that they've been working on. And it says that under the current law, a person commits the offense of endangering the welfare of a child in the first degree if he or she has unlawfully manufactures or possesses amphetamine, methamphetamine, or any of their subsidies. This act would add fentanyl and carfentanil to that. It also changes, as you guys have seen, the term of imprisonment for those found guilty. The second part of this bill, offense of trafficking drugs, changes the percentages. Right now it's 10 milligrams of fentanyl or carfentanil is considered trafficking. This act would change it to no more than 3, but less than 14. And so, I mean, it's the main purpose is trying to get us to the right amount to where our law enforcement can actually, charge and put someone away for trafficking of these drugs that even touching them can kill you. And so with that, I'm happy to answer any questions.
Any questions for bill sponsor? Very briefly. Senator Roberts.
Just on page 14, where it's, so you have it from the 3 to less than 14 milligrams of fentanyl, but then it's just any amount of carfentanil. I'm not familiar with that. Why is it just any amount, and then we have it fentanyl treated differently?
Yeah, fentanyl is actually used in medically. Carfentanil, to my understanding, is not. And so, and I can confirm that that's the reasoning behind this, but that's my understanding of it. And if I find out differently, I will give you a holler.
Sounds good. Thank you.
Witnesses in support of Senate Bill 1451.
Ward Cook on behalf of the prosecutors. We just want to go on record in support.
Right. Perfect testimony. Further witnesses in support? Seeing none. Witnesses opposition? Seeing none. Witnesses for information purposes? Seeing none. Oh, we do actually. Okay, I was too quick. There was just 2 people in the room. I thought maybe we'd get by. Well, and I assume that, you and Ward might be testifying on the exact same side of this given the organizations you work for. So anyway.
I can't testify for anything.
Mr. Sokolov, for informational purposes.
Mr. Chairman and members of the committee, I'm here just very briefly to talk about a technical issue that I think needs to be resolved with this. And if you have it in front of you, page 2, it's subparagraph 12 there under the trafficking first degree. It refers to more than 3 but less than 14 milligrams of fentanyl. The issue is and I don't want to get into a lengthy conversation here about this, but I don't know if you're familiar with the Basel case. Essentially, because the definitional section of the statute, which provides what the offense is, has a upper limit, anything above that would not be prosecutable under this offense. And so but less than 14 grams needs to be taken out there. Obviously, the 14-gram threshold affects the punishment for the enhanced Class A punishment, but it would not, that section would not be given any application because the thing that defines the offense has a 14 milligram threshold. Same thing on trafficking second, that's in the on page 6 at line 38, just striking out those and if this the committee would consider a substitute doing that, as said, I think otherwise the bill's a good idea.
Thank you for your testimony. I appreciate that. If you wouldn't mind working with the bill sponsor on some of those technical amendments.
I actually spoke to to Trey about it and given him the information.
Perfect.
Thank you.
Senator Thompson-Ritter, any concluding remarks?
Thank you.
Right. No further business coming before the committee. I now make a motion that we adjourn. It's been moved and seconded. We are adjourned.